Every effort has been made to ensure the accuracy of the material you are about to hear. However, neither the author nor the publisher accepts any responsibility for how you interpret or act upon this information. It is intended strictly for educational purposes and should not be considered a substitute for professional legal or health and safety advice. You assume full responsibility for your use of this content. Copyright belongs to Intrasafe Pty Ltd 2023. No part of this material may be reproduced, stored in a retrieval system, or transmitted in any form, whether electronically, mechanically, or by photocopying or recording, without written permission from the publisher. This recording is sold or provided solely for educational use and may not be resold or circulated without such consent. Welcome to this legal liability training based on the Occupational Health and Safety Act 85 of 1993, as amended, in the Republic of South Africa. By following along, you will gain knowledge of how the Act functions, the responsibilities of management, and how to apply key principles in daily operations. We encourage you to make personal notes or share insights with others to enrich everyone's understanding of these vital legal obligations. We begin by recognizing that the Occupational Health and Safety Act is rooted in a broader South African legal system. This system has two main elements: common law, which is based on unwritten societal values and norms, and criminal or statutory law, which is formally passed by Parliament. Further influences come from British common law, Dutch civil law, African customary law, and Roman Dutch law. Our present occupational health and safety requirements thus reflect a rich confluence of legal traditions. South African courts are administered by the Department of Justice and Constitutional Development. They include various levels, such as magistrates' courts, district and regional, high courts in each province, the Supreme Court of Appeal, and ultimately the Constitutional Court. Specialized courts also exist, for example, for labor issues or land claims. These courts may become involved in matters arising out of occupational health and safety violations. Legislation often redefines everyday words for legal clarity. An example is the term employee. Commonly, one might say it is a person who works for someone else in exchange for pay. However, in the OHSA, employee is specifically defined to include any person who receives or is entitled to receive remuneration and works under supervision or direction. Similarly, the Labor Relations Act excludes independent contractors from the definition. Always check the OHSA's own definitions when interpreting duties and liabilities. Key common legal terms can also arise in health and safety matters. For example, bona fides indicates good faith, and mala fides indicates bad faith. Diligens pater familias translates to a diligent or careful parent of the family, reflecting a principle that an employer or person in control is expected to act with reasonable care. Dolus covers intentional wrongdoing, while mens rea refers to the mental state of knowingly committing an offense. Mutatis mutandis means that requirements are generally the same but adjusted as needed, and prima facie means at first sight. The phrase reasonably practicable is of particular importance in the OHSA, balancing the severity of a hazard or risk against the resources needed to reduce or remove it. Terminology can be confusing when legislators use everyday words with specialized legal intent. Words like appoint, assign, delegate, and nominate may have overlapping but distinct uses. The OHSA itself clarifies many definitions such as accident, plant, risk, employer, user, and others. When working with OHSA compliance, consult the Act's definitions to avoid misinterpretation. South Africa's occupational health and safety legislation has progressed over decades. The Factories Act was introduced in 1941, the Workmen's Compensation Act in the same year, then the Machinery and Occupational Safety Act in 1983. By 1993, the Occupational Health and Safety Act replaced its predecessors. The OHSA applies broadly to nearly every workplace, though with a few exceptions for mines, certain maritime vessels, and some explosive-related environments. The Act is structured in what we might call 3 layers. First is the Act itself, which Parliament must amend if changes are needed. Second are the regulations, which can be updated by the Minister of Employment and Labor after consultation with the Health and Safety Council. They are more technical and specialized, for instance the construction regulations, driven machinery regulations, or asbestos regulations. Third, recognized standards, whether domestic, such as SANS, or international, like ISO, can be incorporated to reinforce specific safety benchmarks. The minister may also introduce anticipated legislation, such as new hazardous chemical agents regulations or ergonomics-related regulations. These updates appear in government gazettes. Although the core act remains stable, employers must stay informed of changes to regulations or newly adopted standards that affect their industry. Additional laws, such as the Basic Conditions of Employment Act or the Labor Relations Act, can also intersect with OHSA. For example, an employee's health may be protected before and after childbirth, and serious misconduct in the workplace, like willful endangerment of others, can bring labor relations consequences. Employers should recognize that compliance with multiple laws may be required to maintain a safe, fair working environment. The OHSA is self-regulatory. That means the Chief Executive Officer, CEO of every organization, is accountable for compliance. The CEO must ensure that everyone in the chain of command meets responsibilities. Policies are enacted, and incidents are reported promptly. If employees or contractors break the law, liability may be imputed to the employer unless the employer can show that they took all reasonable steps to prevent the act, that the individual was acting outside the scope of authority, and the wrongdoing was not at the employer's connivance. Because the CEO is presumed to be in a diligent parent position, they accept responsibility for employees, non-employees, contractors, and even members of the public who might be exposed to hazards under their control. The Act obliges them to establish proper health and safety management systems, conduct regular inspections, and keep records so they can provide proof of compliance if an incident arises. A well-directed health and safety management system can be viewed as parallel to a financial management system. Instead of tracking income and expenses, the focus is on identifying dangers, implementing corrective measures, and ensuring that workers, visitors, and property remain protected. To achieve that, the system relies on hazard identification, risk assessment, audits, training, transparency, and continuous improvement. Establishing an OHS management system can be seen as a phased process. Phase 1 sets up formal appointments, designates roles like CEO, health and safety representatives, and forms the Health and Safety Committee. Phase 2 concentrates on risk determination through HIRA. Phase 3 is about implementing controls identified in the risk assessment, including the hierarchy of control: removal, replacement, redesign, regulation, education, supervision, and PPE. Phase 4 covers incident management, which involves thorough investigations. Phase 5 includes ongoing monitoring, auditing, and maintaining relevant documentation. Phase 6 fosters an overall safety culture, ensuring that the system remains active and evolves with the organization. Stakeholder lethargy and distraction are common challenges. Reasons range from fatigue and apathy to social or emotional problems, or simply being overworked. Employers and supervisors must anticipate these realities. Through proper training, reminders, discipline when necessary, and leading by example, organizations can keep health and safety top of mind. A robust safety culture helps counter complacency. The OHSA's declared purpose is to provide for the safety of persons at work, persons who use or come into contact with plant or machinery, and persons outside the immediate workplace who could be affected by work activities. It also establishes an advisory council for occupational health and safety, sets the stage for future regulations, and outlines rules for enforcement. The Act contains 50 sections, but not all are equally pivotal for day-to-day compliance. Key provisions include Section 8 on general duties of employers to their employees, Section 9 covering duties to non-employees, Section 13 on providing information, Section 14 on employee duties, Section 16 placing responsibility on the CEO, Section 17 to 20 governing health and safety representatives and committees, Section 24 for incident reporting, Section 25 for occupational disease reporting, Section 37 on acts and omissions by employees or contractors, and Section 38 defining penalties. Various optional or less frequently encountered sections address matters like the advisory council, the appointment of inspectors, formal inquiries, joint inquiries, and so forth. Terminology in the Act includes accident, approved inspection authority, biological monitoring, danger, employee, employer, hazard, health and safety committee, health and safety representative, healthy, inspection authority, listed work, machinery, major hazard installation, mandatory, medical surveillance, occupational health, occupational hygiene, occupational medicine, plant, risk, safe, cell, substance, user, and workplace. Each term carries specific meaning in the context of compliance. There are exceptions to the OHSA. It does not apply to mines, mining areas, or works as defined in the Minerals Act, nor to load line ships, fishing boats, sealing boats, or whaling boats at sea. It also does not apply in certain circumstances involving explosives, unless stated otherwise. Otherwise, it is broadly enforceable. In some cases, technical committees may be formed under the Advisory Council to study specialized issues. For example, experts in chemical hazards might be appointed to recommend updates to the hazardous chemical substances regulations. These committees advise the minister on policy or regulatory changes for the safety and well-being of employees. Employers have general duties to their employees under Section 8. They must provide and maintain a working environment that is safe and without risk, as far as is reasonably practicable. This includes maintaining safe systems of work, taking proactive steps to remove or mitigate hazards, informing and training employees, and providing supervision by knowledgeable persons. Where engineering or administrative controls are not enough, they must supply and enforce the use of PPE. Employees, in turn, must follow these protective measures. Conducting a hazard identification and risk assessment, HIARE, is a prime responsibility. HIRA is a management process to detect and assess any hazards in the workplace, chemical, physical, biological, or otherwise. The results help determine safe working practices, necessary PPE, and training content. An example is the use of a hierarchy of control. One first tries to remove hazards entirely, then substitute them with less harmful alternatives. If a hazard cannot be removed or substituted, it can be redesigned out or otherwise enclosed. Next, administrative controls, like shift rotation, signage, or standard operating procedures, may limit exposure. PPE is always the last resort. Employers must ensure that employees are thoroughly informed, instructed, and trained about the specific hazards and risks in their roles. Section 8 of the Act emphasizes that the training must be sufficient to ensure employees can perform safely. Training can be accredited or in-house, as long as it covers the relevant risk profile. Many regulations reference mandatory or legally required training, such as for forklift operators or first aiders. Legal compliance training can be categorized by the specific regulation. For example, the general safety regulations require first aid training, and the driven machinery regulations require that operators of lifting machines be trained and competent. The hazardous chemical substances regulations mandate worker education on chemical hazards. Depending on the job, more specialized training may be needed. It is ultimately the employer's responsibility to confirm employees have the correct training, not merely the training certificate. Employers are forbidden to allow or require employees to perform certain work unless the necessary control measures and procedures are in place. For instance, untrained personnel must not be assigned to operate complicated machinery or handle dangerous chemicals. Furthermore, Section 8 requires that all safety policies and measures be enforced. Supervisors with the authority to ensure compliance must be appointed and properly coached in recognizing hazards. Every employer must ensure the workplace is under the supervision of a person trained to understand hazards. This is part of the reasonably practicable steps needed to keep a workplace safe. Workers also must be informed about the scope of their authority. Alongside these employer duties, Section 9 extends them to protect persons other than employees, such as visitors, suppliers, or the general public affected by workplace operations. Duties of manufacturers and others who design or supply articles or substances for use at work are clarified in Section 10. Designers and importers must ensure that, when properly used, such items are safe and present no undue risk. They must provide instructions and warnings when hazards are unavoidable. If someone erects or installs an article, that process must not compromise safety. Listed work is a category of tasks designated as especially hazardous. For such work, the Act requires extra steps like additional medical surveillance or occupational hygiene checks. Employers whose operations involve listed work must consult health and safety committees to identify and address the risks. They must also keep employees informed about these special hazards and track employee health over time. When employees are exposed to serious risks, medical surveillance helps detect occupational diseases early. The duty to inform is stressed again under Section 13, which states employers must make sure every employee understands the hazards related to the work they do and the equipment or substances they handle. If inspectors notify the employer of an official inspection or inquiry, health and safety representatives must also be notified. Should an incident occur, representatives must be told so they can investigate and bring feedback to the committee or employer. Information sessions can cover numerous risk-specific topics, such as safe use of chemicals, working at heights, machine guarding, fire safety, first aid, manual handling, or any other identified danger in the workplace. In high-hazard industries, training might address specialized topics like confined space entry or lockout-tagout procedures. A well-structured OHS program includes regular toolbox talks where workers and supervisors discuss safety concerns relevant to daily tasks. Under Section 14, employees at work must take reasonable care for their health and safety, and for the safety of others. They must cooperate with the employer's measures, obey instructions, report unsafe conditions, and report accidents or near misses. Section 15 forbids any person from intentionally interfering with safety equipment or from damaging or misusing items that are provided to protect health and safety. Section 16 places duties on the Chief Executive Officer. The CEO must make sure that the employer's obligations are discharged. They can assign duties to subordinates, but remain responsible if those duties are not met. In a government department, the head of the department is deemed the CEO for these purposes. Because vicarious liability exists, the CEO can be held accountable if the organization systematically fails to comply, unless they show that they took every reasonable step to ensure compliance.